Hello, my name is Justin Prochnow. I'm a U.S. attorney in the Denver, Colorado office of the international law firm Greenberg, Traurig. My law practice focuses on representing companies in the food, beverage, and dietary supplement industries. Today, I'm going to talk to you a little bit about the regulation of sweeteners in the United States. First, we're going to talk about what regulatory requirements there are for sweeteners, whether they have to be approved food additives or GRAS. Then we're going to talk about how those sweeteners are labeled on products in the United States. We'll talk about certain claims that can be made for sweeteners. And finally, we'll talk about the growing class action litigation over claims made for sweeteners and other ingredients in the United States. All ingredients in foods in the United States, other than colors, are known as food additives. Food additives are defined in the Federal Food, Drug, and Cosmetic Act. The Federal Food, Drug, and Cosmetic Act is the main body of laws that governs products in the United States. Food additives are essentially any substance added to food other than pesticides and color additives. Food additives must be approved food additives or known as GRAS, which is generally recognized as safe, or a product may be deemed adulterated. Ingredients may be GRAS by regulation, or they may be self-affirmed GRAS through history of use or scientific agreement. The Code of Federal Regulations is a body of regulations that were implemented by the FDA to help enforce the Federal Food, Drug, and Cosmetic Act. FDA-approved food additives can be found in the Code of Federal Regulation from Parts 172 to 178. Meanwhile, those food additives that have been recognized as GRAS can be found from Parts 182 to 186. These regulations contain a variety of sweeteners, ranging from sucrose, otherwise known as sugar, to high-intensity sweeteners. These regulations often include limitations on the use, but they don't always, and some may have no limitations on use. Additionally, some of these regulations contain warnings that are required for certain sweeteners, such as aspartame or sorbitol. For example, sucrose can be found at 21 CFR 184.1854. Sucrose, otherwise known as sugar, cane sugar, or beet sugar, is GRAS, remember, generally recognized as safe, by regulation. High fructose corn syrup is also GRAS by regulation and can be found at 21 CFR 184.1866. Other food items that are often used as sweeteners in the United States, such as syrup, agave, honey, and fruit juice, are GRAS through their common use in food prior to 1958. So there's no specific regulation which identifies them as GRAS, but they've been commonly used in food for a long period of time, so the FDA also recognizes them as GRAS. Many of the sugar alcohols, such as sorbitol, xylitol, lactitol, mannitol, erythritol, and maltitol, are also sugar substitutes, with some being approved food additives and some GRAS by regulation. These sugar alcohols vary from 25% to 100% as sweet as sugar, and they're used primarily to sweeten sugar-free candies, cookies, and chewing gum. High-intensity sweeteners are artificial sweeteners that are often used as sugar substitutes. High-intensity sweeteners are many times sweeter than sugar with little to no calories. They are regulated as food additives unless they've been already established as GRAS. There are 6 high-intensity sweeteners that have been FDA approved as food additives. The first was saccharin, which was used over 130 years ago. Aspartame was the next one, which was approved as a food additive by the FDA in 1981. Then we have ACE sulfame potassium, otherwise known as ACE-K, was approved in 1988. Sucralose, one of the more common high-intensity sweeteners, was approved in 1998. Neotame was approved in 2002, and most recently, Advantame was approved just last year in June of 2014. Aspartame is an example of one of those sweeteners that has a standard of identity that includes some warning requirements. Aspartame has these warning requirements due to potential safety issues with PKU, also known as phenylketonuria. Products containing aspartame must include the following warning in capital bold letters: phenylketonurics, contains phenylalanine. This statement must be prominent and conspicuous and in bold type on a contrasting background. Additionally, when aspartame is used as a sugar substitute for table use, it must be labeled that it should not be used for cooking or baking. If an ingredient is not an approved food additive or GRAS by regulation, a company may also establish the GRAS status of an ingredient through the self-affirmation process. GRAS notices have been submitted for 2 different types of sweeteners. A number of GRAS notices have been submitted for Reb A, which is a certain steviol glycoside obtained from the leaves of the stevia plant. In addition, several submissions have been made for monk fruit extracts. It's important to note that GRAS notices do not pertain globally to an ingredient. So just because one company has submitted a GRAS notice for a particular ingredient, it does not mean that it's GRAS across the board. The GRAS notices are specific to the uses identified in the GRAS notice and to the company submitting the notice. If an ingredient supplier submits a GRAS notice and the uses are kept within the purpose stated in the GRAS notice, anyone using that particular form of the ingredient can avail themselves of the GRAS status. So this is often a course of action for ingredient suppliers so that they can tout their ingredient as GRAS affirmed. The FDA does not specifically approve GRAS submissions, but issues a statement indicating FDA has no questions. For this reason, since you are not required to submit GRAS notices, many companies keep them in their file, but do not submit them to the FDA. The FDA has received 25 GRAS notices for Reb A and 2 GRAS notices for monk fruit, with FDA has no questions responses. While a number of sweeteners have been approved as food additives or GRAS in the United States, several sweeteners have been prohibited in the United States. Cyclamates and its salts have been prohibited for use in the United States. While they were initially on the GRAS list, cyclamates were removed from the list of GRAS ingredients in 1969, following reports that they were causing liver tumors in rats. A food additive petition for cyclamates was denied by the FDA on September 5, 1980. In addition, stevia, in its crude form or in whole leaf form, are not allowed for use in food products in the United States, although they are allowed for use in dietary supplements. We've talked a little bit about how sweeteners are regulated in the United States. Now I would like to talk a little bit about how sweeteners are identified on the label of a food product. If a food product contains sugars, the number of grams of sugars must be declared in the nutrition facts panel as a subcategory under total carbohydrate. Sugars are defined as the sum of all free mono and disaccharides such as glucose, fructose, lactose, and sucrose. If a product contains less than 1 gram of sugars in a serving and no claims are made about sweeteners, sugars, or sugar alcohol content, then sugars don't have to be listed. If a statement of the sugar's content is not required and as a result not declared, the statement "not a significant source of sugars" must be placed at the bottom of the nutrition facts panel, just above the footnote that indicates percent daily values are based on a 2,000 calorie diet. You can see an example of a nutrition facts panel that contains sugars to the right. Essentially, there are 3 types of claims that you can make for food products in the United States. Nutrient content claims, which describe a particular level of a nutrient in a product. Structure function claims, which describe the effect of an ingredient or nutrient on the structure or function of the body, and health claims. The first category of claims that I'd like to talk to you about are nutrient content claims. As I indicated, nutrient content claims are claims that expressly or implicitly characterize the level of a particular nutrient in a product. An example of an express claim would be sugar-free. You are indicating that there is no sugar in the product. An implied claim would be something like only 5 grams of sugar. You're implying that there is a low level of sugar in the product by use of the word only. Nutrient content claims can only be made if they are specifically provided for in the Code of Federal Regulations. And the regulations pertaining to nutrient content claims can be found at 21 CFR 101.13 or in the regulations from 21 CFR 101.54 to 101.65. Any claims that a product is low or free of a nutrient when the product has not been specially processed, altered, formulated, or reformulated to qualify the claim must refer to all foods and not just the particular brand. So for example, if you made a claim that your celery has 0 grams of sugar, no celery contains sugar. So you would have to provide an additional disclosure that indicates celery is a sugar-free food. Interestingly, there are actually no claims that allow for low sugar claims because there is no accepted daily value for sugar. So there's no baseline to make a statement that it contains low sugar or not. You cannot make a low sugar claim. There are certain regulations which allow for some nutrient content claims related to sugar. 21 CFR 101.60 allows for a no sugar or 0 grams of sugar claim. You can make such a claim when a product contains less than half a gram of sugar per recommended amount customarily consumed or the serving size. There is no other ingredient that is a sugar, and it's labeled low calorie, or if it's not a low calorie food, it has a statement that indicates it's not a low calorie food next to the sugar-free claim. 21 CFR 101.60 C2 also allows for no added sugar claims. No added sugar claims can only be made if there is no amount of sugars or any other ingredient that contains sugars that functionally substitute for added sugars, and they are added during processing or packaging. In addition, the product may not contain any ingredient that contains added sugars, such as jam, jelly, or concentrated fruit juice. Enzymes may not have been added to increase the sugar content, and the product must bear a statement that the food is not low calorie and direct consumers' attention to the nutrition panel for information on sugar and calorie content if it is not a low calorie product. That disclaimer would look something like the following, which says, not a low calorie food. See nutrition information for sugar and calorie content. While you may not make a low sugar claim, 21 CFR 101.60 subsection C5 does allow for less sugar or lower in sugar claims in certain situations. You may make these types of claims only if the food contains at least 25% less sugar than an appropriate reference food. So you must have a food that you're comparing your product to. The identity of the reference food and the percent or fraction that the sugar differs must be declared in immediate proximity to the most prominent claim. So if you have a claim of less sugar on the front panel of your product, you must have a disclosure that indicates something like, these cornflakes contain 25% less sugar than our sugar-coated cornflakes. You must then also provide quantitative information comparing the exact levels of sugar in the product with that of the reference food, adjacent to the nutrition information. So that statement would look something like this. Sugar content has been lowered from 8 grams to 6 grams, or our product, 8 gram sugars, Y product, 6 gram sugars. The next category of claims that are often used to promote food products in the United States are structure-function claims. As I indicated earlier, structure-function claims are claims that describe a particular nutrient or ingredient and that nutrient or ingredient's effect on the structure or function of the body. Structure-function claims were specifically authorized for use in promoting dietary supplement products in the Dietary Supplement Health and Education Act of 1994. The FDA has allowed structure-function claims for food products also, as long as they relate to aroma, taste, or nutritive value. A fundamental principle of structure-function claims is that they may not promote a product to diagnose, treat, cure, or prevent any disease. With respect to sugar or sweeteners, Structure-function claims addressing their effect on the structure or function of the body would likely be permissible because they would relate to taste or to nutritive value. So claims such as sugar builds muscle tissue, as long as you have scientific evidence to support that statement, would be a permissible claim. However, claims related to increasing blood sugar related to diabetes would be treated as disease claims, making the product a drug. Claims about reducing sugar content to avoid diseases would also be viewed as disease claims, such as this example of an ad below. The last category of claims that I wanted to tell you about briefly today are health claims. Health claims are the one exception to the general rule that you cannot sell a non-drug product to diagnose, treat, cure, or prevent a disease. Health claims are claims that discuss a particular ingredient or nutrient and its effect on a particular disease. There are specific claims that have been authorized by the FDA as health claims and that are set forth in the Code of Federal Regulations from 21 CFR 101.72 to 21 CFR 101.83. Specifically with respect to sweeteners, there is a health claim found at 21 CFR 101.80. That regulation indicates the relationship between dietary, non-karyogenic carbohydrate sweeteners, sugar alcohols, and sucralose, and dental caries. A permitted health claim subject to this regulation would be something like the following. Frequent between-meal consumption of foods high in sugars and starches promotes tooth decay. And then you would indicate whether it was sugar alcohols, sucralose, whatever is in your product, does not promote tooth decay. This would be a permissible health claim and an exception to the general rule of discussing the diagnosis, treatment, cure, or prevention of disease in a food product. The last category that I wanted to touch on briefly related to sweeteners in the United States is civil litigation. Litigation in the United States over food labeling claims has literally exploded over the last 5 years. There's been a wave of litigation that actually started back in the middle 2000s with actions against Ben & Jerry's and certain beverage manufacturers that were touting their products as all natural and containing high fructose corn syrup. That litigation has moved on to a variety of other products, and California is the center of litigation due to 3 consumer-friendly statutes: the Consumer Legal Remedies Act, the False Advertising Law, and the Unfair Competition Law. Specifically with respect to sweeteners, litigation may appear in the following contexts: litigation over improper nutrient content claims, litigation over false claims related to sugar content, actions over the use of all natural with alleged synthetic ingredients like alkalized cocoa, high fructose corn syrup, or other potentially processed ingredients, or alleged misleading names of ingredients, such as evaporated cane juice, which the FDA has indicated should be called evaporated cane sugar or just plain sugar. This litigation has not generally been consumer-driven. These lawsuits are driven by plaintiffs' lawyers that have made this their new course of business. As I indicated, some of the litigation has been over improper nutrient content claims. There was a lawsuit against Mott's apple juice for apple juice and applesauce that contained no sugar added claims. Additionally, there was a lawsuit against a yogurt company with a total 100% product sued for implying that the product has no sugar. FDA warning letters over improper nutrient content claims often provide kind of a roadmap to plaintiffs' lawyers to allow them to more easily bring a class action lawsuit over the same topic. If the sugar content doesn't actually meet the label claim in a nutrition facts panel, this could also be the source of a false or misleading claim. So if you indicated that a product has 4 grams of sugar, as we saw on the previous nutrition facts panel example, and instead your product really has 7 grams of sugar, that could be the source of a false or misleading class action lawsuit here in the United States. While we have seen some litigation over improper nutrient content claims, the large majority of litigation has occurred over all natural claims. Ingredients that have been the targets of class action lawsuits have included ingredients that are non-GMO, synthetic chemical preservatives, high fructose corn syrup, and alkalized cocoa. Sweeteners that have been the subject of all natural litigation include high fructose corn syrup, evaporated cane juice, and stevia in products like ice cream, beverages, and yogurts. The last category of litigation that I wanted to discuss briefly is the proper identification of the name of an ingredient in the list of ingredients. A sweetener that the FDA has brought attention to is evaporated cane juice. In 2011, the FDA issued a draft guidance for industry that indicated it believed that the use of the name evaporated cane juice was misleading to the public because it implied that it might be healthier by use of the word juice than it might otherwise be. And the FDA indicated that it believed companies should use the word sugar in the name, such as evaporated cane sugar or even evaporated cane syrup, or just use sugar itself to identify the ingredient. While this guidance is not law, it does have the effect of plaintiffs' lawyers using that guidance as the basis for a number of class action litigations, indicating that the FDA believes that this claim is false or misleading. A lot of that litigation is currently put on hold in the United States, as the FDA has indicated that it will revisit that guidance to see whether any revisions or updates need to be made. That completes this brief webinar on the regulation of sweeteners in the United States. You'll see a brief disclaimer from me here about my comments and the fact that this is my opinion and not the opinions necessarily of my law firm, and that by providing this information, it does not create an attorney-client privilege or relationship between the viewers and myself. My contact information is here, and I would be happy to answer any questions or to assist you as the opportunity may arise. Thank you.